The note was folded, small, the kind of paper you find in a kitchen drawer, torn from a notepad, creased at the corners, unremarkable in every possible way. Police found it inside Lucy Letby's home during a search in 2018. They unfolded it, they read it, and for a moment even veteran investigators went quiet, written in her own hand, in blue ink, in the deliberate capital letters of someone who wanted the words to carry weight. I am evil. I did this. Below that, in the same handwriting, I killed them on purpose because I am not good enough to care for them. I am a horrible, evil person, a single piece of paper, a confession that no one had forced out of her, no interrogation, no pressure, just a young woman alone in her house, writing down what she believed herself to be. Or so the prosecution argued. The defense told a different story. They said those words were the product of a therapy technique, a method taught to teenagers in peer support sessions at school, where you write your darkest thoughts on paper to release them, not because they are true, but because carrying them silently is worse. They said the same notepad contained the words, I haven't done anything wrong, that it also said slander, that it said discrimination, that a confession and a denial written on the same page, in the same hand, by the same person, cannot both be true, and that the prosecution chose which parts of the paper mattered. The jury believed the prosecution. In August 2023, after one of the longest murder trials in British legal history, Lucy Letby was convicted of murdering 7 babies and attempting to murder 7 others. She became the most prolific child killer in the United Kingdom's modern history. She was sentenced to 15 whole-life orders, meaning she will die in prison with no possibility of parole. Only 3 other women in British history have received that sentence. One of them was Myra Hindley, one of them was Rosemary West. And yet the debate has not ended. In February 2025, 14 international medical experts, neonatologists, statisticians, forensic scientists held a press conference and announced that after reviewing all the medical evidence, they had found no proof that Lucy Letby had harmed a single baby, that natural causes, premature birth, and inadequate hospital care could explain every death, that the science used to convict her was not science at all, but interpretation dressed up as certainty. The case is currently under review by the Criminal Cases Review Commission. Either Lucy Letby is one of the most methodical, hidden, and remorseless killers in British legal history, a woman who murdered infants in a neonatal ward for reasons no one has ever been able to explain, or she is an innocent woman serving 15 life sentences for crimes she did not commit, convicted on evidence that leading experts now say was fundamentally flawed. This is the full story. Lucy Letby was born on the 4th of January, 1990, in Hereford, a quiet cathedral city in the west of England, close to the Welsh border. The kind of place where people stay for generations, where everybody knows your family's name. She was an only child. Her father, John, worked as a furniture salesman. Her mother, Susan, worked in accounts. By all accounts, they were a stable, ordinary family. No dysfunction, no documented trauma, no history of mental illness or violence. Neighbors on the street where Lucy grew up described her parents as well-liked, pleasant people, and described Lucy herself as a normal, happy, smiling child. She attended St. James's Church of England Primary School, then Aylstone School, then Hereford Sixth Form College. According to a friend interviewed by the BBC, Lucy had wanted to be a neonatal nurse for as long as anyone could remember. Not a general nurse, not a pediatric nurse, but a neonatal nurse specifically. Someone who worked with the smallest and most vulnerable patients, premature babies, sick newborns, infants who had arrived in the world before the world was ready for them. That specificity would later become a data point for the prosecution, a deliberate choice of the most helpless possible victims. But at the time, it was simply the ambition of a focused young woman who knew what she wanted. She was the first person in her family to attend university. She enrolled at the University of Chester, graduated with a Bachelor of Science in Child Nursing, and in January 2012 began working full-time at the Countess of Chester Hospital, a medium-sized NHS trust in northwestern England, roughly halfway between Liverpool and Wales. She was 21 years old. Her colleagues in the years before everything fell apart described her consistently using the same vocabulary: dedicated, professional, caring, reliable. She worked overtime. She volunteered for extra shifts. She was known informally as Nice Lucy, a nickname that carried no irony at the time it was given. She was the nurse you wanted assigned to your baby, the one who stayed late, the one who knew your child's file better than anyone else on the unit. In January 2015, after 3 years on the ward, Letby became fully qualified to work as a neonatal intensive care nurse. She was assigned to some of the most critical cases in the unit, the sickest babies, the ones with the worst prognoses, the ones who required the highest level of attention and skill. It was a mark of trust, a recognition of competence. 3 months after her qualification, the deaths began. To understand what happened at the Countess of Chester Hospital between June 2015 and June 2016, you need to understand the environment in which it happened. Neonatal intensive care units are, by their nature, places of fragile outcomes. The patients are often extremely premature, born at 24, 25, 26 weeks, when the lungs are not yet fully formed, when the brain is still developing, when the immune system offers almost no protection against the outside world. Death is not rare in a NICU. Sudden deteriorations are not rare. Outcomes that seem inexplicable to the untrained eye are not rare. When a baby collapses without warning in a neonatal unit, the first assumption is always a medical cause: infection, respiratory failure, cardiac anomaly, a complication of prematurity. That is precisely the environment in which, the prosecution argued, Lucy Letby operated. She understood it perfectly. She knew that sudden infant deterioration would not immediately trigger suspicion. She knew the language of neonatal medicine well enough to perform it convincingly. And she knew, according to the prosecution, that the method she used, injecting air into bloodstreams, administering insulin through feeding bags, force-feeding milk in dangerous quantities, would be difficult to distinguish from natural causes in a unit already accustomed to unexpected tragedy. The prosecution called her a constant, malevolent presence. The defense called her a highly qualified nurse who was assigned to the sickest babies precisely because she was trusted, and who was present at deaths and deteriorations because that was what her job required. Both of those things are factually true. The question is what they mean. June 8th, 2015. The morning shift was underway at the neonatal unit. A premature twin boy, referred to throughout the trial as Child A, was in the intensive care section of the ward. He had been born early, like all the children in that unit, and his condition required close monitoring. He was connected to monitors that tracked his oxygen levels, his heart rate, his breathing. The alarms were calibrated to alert nurses the moment something changed. That morning, something changed. Child A stopped breathing. He deteriorated with a sudden completeness that even experienced neonatal nurses found alarming. Not a gradual decline, but a collapse. The crash team was called. Everything available to modern neonatal medicine was used. It was not enough. 38 minutes after the emergency began, Child A was declared dead. He was the first confirmed victim, according to the prosecution. The method used, investigators would later argue, was the injection of air directly into his intravenous line, a procedure that creates what is known as an air embolism, a bubble of gas that travels through the bloodstream and blocks blood flow with lethal efficiency. It leaves almost nothing behind, no mark, no wound, no obvious trace in a standard post-mortem unless the pathologist specifically knows to look for it. The next day, 24 hours later, Lucy Letby was on shift again. Child B, the twin brother of Child A, was still in the neonatal unit. He was suddenly found to be deteriorating. He was resuscitated. He survived. 3 infants died at the Countess of Chester Hospital in June 2015 alone, equal to the total number of deaths the unit had recorded across the entire previous year. The consultants noticed. Of course they noticed. 3 deaths in 1 month, in a unit that size, in a period that short, that was not statistically plausible as coincidence. They began to track the numbers. They began to talk among themselves. They began to notice something that, in retrospect, they would describe as the most disturbing pattern of their professional lives. In nearly every case, in every unexpected death or near-fatal collapse in that neonatal unit, one name appeared consistently in the shift records: Lucy Letby. By July 2015, senior consultants at the hospital had already begun expressing their concerns, quietly, internally, within the professional channels available to them. They brought their data to hospital management, charts showing the correlation between Letby's shifts and adverse outcomes, incident reports, statistical analyses. They were careful. They were precise. They were doctors who understood what the numbers meant and were terrified of what they were suggesting. Hospital management listened. And then, for reasons that would later become the subject of a separate public inquiry, hospital management did very little. Letby remained on the unit. The deaths continued. Over the following 12 months, the prosecution documented attack after attack, air injected into bloodstreams, feeding tubes manipulated, insulin added allegedly to feeding bags, causing blood sugar levels to crash in ways that looked at first glance like a complication of prematurity, a baby force-fed milk in quantities that distended the stomach, restricting the lungs' ability to expand. A baby whose liver was damaged by blunt force, a detail that had no natural explanation in a premature infant who had not been dropped or handled roughly. 7 babies died. 7 more survived, though some of them with lasting consequences. 1 infant, attacked multiple times, was left with severe disabilities. In July 2016, 13 months after Child A's death, hospital management finally acted. Letby was removed from the neonatal unit and reassigned to administrative duties. She resisted, she protested. She was, by contemporaneous accounts, deeply distressed by the reassignment. She attended a meeting with hospital management and reportedly broke down. She sent text messages to colleagues saying she did not understand why this was happening to her. She seemed, to those around her, genuinely bewildered, or she performed bewilderment with extraordinary conviction. The deaths stopped. The moment Lucy Letby left the neonatal unit at the Countess of Chester Hospital, the anomalous deaths stopped. The prosecution would call that the most powerful piece of evidence in the entire case. The defense would call it the most dangerous kind of correlation, the kind that feels like proof but proves nothing. In the spring of 2017, a letter arrived at the headquarters of Cheshire Police. It was addressed to the Chief Constable and came from an unlikely sender, the Chief Executive of the Countess of Chester Hospital. The letter described what the hospital had been tracking for nearly 2 years, an unexplained and statistically unprecedented surge in deaths and near-fatal collapses in the neonatal unit. Doctors were baffled. Internal reviews had found no systemic cause, and consultants on the unit had begun to raise, quietly and with increasing urgency, the possibility that someone was doing this deliberately. Detective Superintendent Paul Hughes was assigned to the case. He met with 3 senior consultants at the hospital to hear what they had found. He would later describe the meeting in 2 words, the same 2 words the doctors themselves had used: unexplained and unexpected. Operation Hummingbird was formally launched. At its peak, the investigation would involve nearly 70 officers and civilian staff. Over 32,000 pages of evidence were gathered. Approximately 2,000 people were interviewed. 250 potential witnesses were identified. Investigators worked backwards through the hospital's records with painstaking care, cross-referencing shift rotas against incident reports, matching the presence of specific nurses against specific collapses, looking for the pattern hidden inside what the hospital had, for too long, been willing to accept as medical tragedy. The pattern was always the same: one name, one face. One softly spoken young woman from Hereford who worked overtime, who was trusted with the sickest babies, who colleagues described as dedicated and professional. Nice Lucy. On the morning of July 3, 2018, police vehicles arrived at a residential street in Chester. Lucy Letby, then 28 years old, was led from the front door of her home in handcuffs. She was wearing a blue hoodie. She did not struggle. She did not shout. She was calm, according to officers present, almost unnervingly calm, in the way that someone is calm when they have already decided how to behave. She was taken to a police station and questioned for hours. Detective Superintendent Hughes later described those interviews as among the most unsettling of his career. Not because Letby was aggressive or evasive or frightened, but because she was none of those things. She answered questions with a clinical precision. She did not cry. She did not rage. She did not pound the table and demand that investigators find the real killer. According to Hughes, she showed no overt empathy when discussing the children who had died, no spontaneous grief, no distress at the mention of specific names and specific moments. He described her as emotionless, as difficult to read, as someone who responded in ways he would not have expected from an innocent person. But the absence of visible grief is not evidence of guilt. Experienced interviewers know that trauma manifests differently across different people. Some innocent people are paralyzed by shock. Some become controlled, mechanical, dissociated. The absence of the expected response tells you something, but it does not tell you everything. Letby was released on bail. She was arrested a second time in 2019, released again, arrested a third time in November 2020 following further investigation. This time, she was remanded in custody and formally charged. 7 counts of murder and 10 counts of attempted murder. The trial began at Manchester Crown Court in October 2022. What happened in the year between the doctors raising their concerns and the hospital contacting the police reveals a dimension of the Lucy Letby case that has since become the subject of a separate criminal investigation. The consultants at the Countess of Chester Hospital first brought their data to senior management in early 2016. They presented statistical analyses. They presented correlation charts. They presented, with as much professional restraint as they could manage, a case that the unexplained deaths in their unit could not be accounted for by natural causes, and that one person was present at virtually every one of them. The response from management was not to investigate. It was to push back. Hospital executives, the subsequent public inquiry heard, were disbelieving. They questioned the doctor's methodology. They questioned their judgment. The hospital's chief executive, Tony Chambers, reportedly told a colleague after Letby's first arrest in 2018 that he was confident she would face no charges, that he was worried about a wrongful conviction. Senior managers who had received warnings about the pattern of deaths did not escalate the matter to police. They did not commission an independent medical review. They did not suspend Letby from the unit while the concerns were investigated. Instead, in July 2016, they moved Letby to administrative duties, and then, when she objected, forced her to attend a meeting with the very consultants who had raised concerns, as though the appropriate response to a potential serial killer in a neonatal unit was mediation. The doctors were appalled. Some of them were directed to write letters of apology to Letby for the harm caused by their concerns. They refused. At least one consultant later described that period as one of the most professionally and morally agonizing of his life. Watching babies die, raising the alarm repeatedly, and being met with institutional inertia while the person they suspected remained on the ward. In October 2023, following Letby's conviction, Cheshire Police launched a separate investigation, Operation Duet, into the conduct of senior hospital management during the period in question. By March 2025, the scope of that investigation had been widened to include not only corporate manslaughter, but gross negligence manslaughter of individuals. 3 former members of the hospital's senior leadership team were subsequently arrested on suspicion of gross negligence manslaughter, bailed pending further inquiries. The question that Operation Duet is attempting to answer is not whether Lucy Letby killed those babies. That question, in the eyes of the law, was answered in August 2023. The question Operation Duet is asking is, how many of those deaths could have been prevented if the people in authority had listened to the doctors who were telling them something was terribly wrong? The trial of Lucy Letby lasted approximately 10 months, one of the longest murder trials in British legal history. 246 witnesses testified. Thousands of documents were presented, examined, cross-examined. 6 expert medical witnesses appeared for the prosecution. The evidence covered 17 separate children, 7 who died, 10 who survived with varying degrees of harm. The prosecution's case, presented by barrister Nick Johnson KC, was built on several interlocking pillars. The first was statistical. Letby was present for virtually every unexplained death and near-fatal collapse in the unit during the relevant period. The prosecution presented this not as the only evidence, but as the framework within which all other evidence should be understood, the structural fact that made everything else coherent. A nurse who works extra shifts will naturally appear more often in any incident log, but the correlation in this case, the prosecution argued, went far beyond what probability could explain. The second pillar was forensic. For two of the babies, referred to in court as Child F and Child L, blood tests revealed abnormally high levels of insulin combined with abnormally low levels of C-peptide. That specific combination, high insulin, low C-peptide, occurs in only one clinical scenario, when synthetic insulin is introduced into the body from an external source. The baby's own pancreases were not producing the insulin. Something else was. The prosecution argued that Letby had added insulin to their feeding bags, causing hypoglycemia severe enough to trigger collapse. The insulin cases were the first on which the jury reached a verdict. They believed the prosecution, and believing the prosecution on those two counts made the rest of the case, the air embolisms, the force feeding, the unexplained collapses, significantly more credible. The third pillar was behavioral. Letby had searched the names of several victims' parents on Facebook after their babies died. She'd sent a sympathy card to the family of a baby she was accused of murdering, a baby she had allegedly attacked 4 times. She had remained on the unit after concerns were raised, when a less determined person might have requested reassignment to avoid suspicion. And she had, the prosecution argued, demonstrated in her text messages and communications during the period a level of proximity to death that crossed the line from professional engagement into something else, something that looked, in retrospect, like interest. The fourth and most contested pillar was the notes. Detectives found them during the search of her house in 2018. A notepad, pages torn at different times, different inks, different degrees of pressure in the handwriting, and scattered across those pages, in Lucy Letby's own hand, words that the prosecution placed before the jury as evidence of the most intimate kind. I am evil. I did this. I killed them on purpose because I am not good enough to care for them. I am a horrible, evil person. Those phrases were placed on screens in the courtroom. They were read aloud by the barrister. They were shown to the jury and presented as the voice of a killer processing what she had done. Not a full confession, but something close enough to devastate any defense. The defense did not deny that Letby had written the notes. They could not. The handwriting was hers. The paper was from her home. The notes were undeniable. Instead, they offered a different framework for understanding them. Lucy Letby had been removed from her job under suspicion of killing children. Her reputation had been destroyed. Her colleagues, people she had worked alongside for years, had formally reported her to hospital management as a potential murderer. She was under investigation. She was alone. And according to a childhood friend named Dawn, who had known Letby since they were at Ayleston School together, Lucy had learned during her school years a particular method of emotional processing, the practice of writing down your darkest thoughts, however irrational, however extreme, in order to release them. Not because the thoughts were true, but because leaving them inside was worse. Dawn described the technique, taught, she said, during peer support training sessions when they were teenagers, as a deliberate, therapeutic practice. You write the worst thing you can imagine thinking about yourself. You put it on paper. You externalize it. The writing is not a confession. It is a release. The defense also noted what the prosecution had not emphasized. The same notepad contained other phrases. I haven't done anything wrong. The word slander circled. The word discrimination. A person who writes both I am evil, I did this, and I haven't done anything wrong on the same pad is not producing a coherent confession. They are producing the fractured, contradictory output of a mind under extreme stress. The jury was not persuaded. On the 18th of August 2023, after nearly 10 months of testimony, legal arguments and forensic deliberation, the jury at Manchester Crown Court returned its verdicts. Guilty, 7 counts of murder. Guilty, 7 counts of attempted murder. The jury was discharged without reaching verdicts on 4 additional counts. But on the core question, whether Lucy Letby had murdered 7 babies and attempted to murder 7 others, 12 jurors agreed, unanimously, after deliberating for approximately 22 hours spread across 4 days. Lucy Letby was not in court to hear the verdicts read. She had been present for the duration of the trial, seated in the dock, day after day, through nearly 10 months of evidence about children who had died and children who had survived with injuries and disabilities. She had listened to parents describe the moment they were told their baby was gone. She had sat through the reading of her own notes, "I am evil, I did this," projected onto a screen visible from the dock. Through all of it, she had shown, in the consistent assessment of observers, almost no outward emotional response. But she did not come to court on the day the verdicts were read. And she did not come for her sentencing. On the 21st of August 2023, Justice James Goss addressed an empty dock. Lucy Letby had refused to attend. He sentenced her anyway to life imprisonment with a whole life order on each and every offence. 14 whole life orders in total, an unprecedented number. She became only the 4th woman in British legal history to receive a whole life sentence, joining Myra Hindley, Rosemary West, and Joanna Dennehy. The sentence meant one thing with absolute clarity: she would never leave prison. There was no tariff to serve, no review date, no possibility of parole. She would die inside HM Prison Bronzefield. The judge described her crimes as a cruel, calculated and cynical campaign of child murder involving the smallest and most vulnerable of children. He described the cruelty and calculation of her actions as truly horrific. He addressed her directly, as if she were present, so that she would receive a transcript of his words. The parents of the victims read their statements in open court. One mother described the murder of her son as something out of a horror story. Others described children who had survived Letby's attacks but would never fully recover. Permanently disabled in some cases, as a result of injuries sustained in what should have been the safest possible environment. A hospital ward surrounded by trained medical professionals, under fluorescent lights, with monitors beeping and nurses circling, and every safeguard modern medicine could provide. And still she had done it, or so the law had decided. The aftermath of a conviction of this magnitude rarely produces silence. In the case of Lucy Letby, the silence lasted approximately 1 year. Then, in 2024, a long-form article appeared in the New Yorker magazine. It had been blocked from publication in the United Kingdom for a period due to legal constraints around ongoing proceedings, but it eventually circulated. Journalist Rachel Aviv had spent months investigating the case, and what she found troubled her. Not necessarily because she believed Letby was innocent, but because the process by which she had been found guilty was, in Aviv's assessment, deeply flawed. The statistical evidence was less decisive than the prosecution had presented it. The medical evidence relied on expert interpretation that was, in several instances, genuinely contested within the relevant medical specialties. The post-it notes, Aviv argued, had been framed by the prosecution in a way that stripped them of their full context. The article did not exonerate Letby, but it opened a question that the verdict had seemed to close. Then came February 4th, 2025. On that morning, a press conference was held at a venue in Westminster, London. In attendance was a panel of 14 international medical experts, neonatologists, pediatric specialists, a senior intensive care nurse, a biomedical engineer. They had been convened by Dr. Shu Li, a retired neonatologist and Professor Emeritus of Pediatrics at the University of Toronto and the founding president of the Canadian Neonatal Foundation. Dr. Li's presence was significant for a specific reason. He was the co-author of a 1989 academic paper on air embolisms in neonates, the very paper that the prosecution's lead expert, Dr. Dewey Evans, had cited throughout the trial as evidence that Lucy Letby had injected air into babies' bloodstreams. Dr. Li had read the trial transcripts. He had reviewed how his paper had been used, and he was not happy with what he found. Standing before the assembled journalists, he spoke in the measured, careful language of someone who understood precisely what he was saying. His panel had reviewed all 17 cases from the trial, all 7 murders, all 10 attempted murders. They had examined the medical evidence, the pathology reports, the blood test results, the X-rays, the clinical notes, and their conclusion was unambiguous. We did not find any murders. In all cases, he said, death or injury were due to natural causes or just bad medical care. He said the evidence used to convict her was wrong. He said the specific interpretation of air embolism evidence, the interpretation that had been attributed in part to his own published research, was a misreading of what his paper actually established. He said the hospital at Chester, had it been operating in Canada, would have been shut down for substandard care. The panel found evidence of dangerous bacterial infections that had gone undetected, errors in the insertion of breathing tubes and intravenous lines, a failure to administer antibiotics in a timely manner, a neonatal unit that was, in multiple documented respects, operating below acceptable standards. They found, in other words, an alternative explanation for the cluster of deaths, one that did not require a killer at its center, one that required only a struggling, under-resourced hospital doing inadequate work on the most fragile patients imaginable. The mother of one of Letby's victims, who cannot be legally identified, told the press that the panel's conclusions were disrespectful and upsetting. The families of the victims had been through 2 trials, multiple appeal hearings, and the daily burden of knowing their children were dead, and the woman convicted of killing them was alive in prison. And now they were being told that perhaps it had never happened at all, that the deaths were not murders, that the woman serving 15 life sentences for the worst crime a neonatal nurse can commit had, in the view of 14 international experts, committed no crime whatsoever. The lawyers for the victims' families dismissed the panel's conclusions as full of analytical holes, a rehash of defense arguments that had already been considered and rejected by 2 separate juries. And they had a point. The justice system had already evaluated the evidence. Twice, 2 separate juries, in 2 separate trials, had heard expert witnesses on both sides, had been directed by judges on the law, had deliberated in private, and had reached the same conclusion. The threshold for overturning a jury verdict in the British legal system is deliberately high, not because the system is arrogant, but because the alternative is chaos. If every verdict can be relitigated by a panel of experts with different opinions, the concept of a jury trial becomes meaningless. But the counter-argument carries equal weight. The history of criminal justice in the United Kingdom and everywhere else is not a history of perfection. It is a history of wrongful convictions overturned, of evidence later shown to be flawed, of expert witnesses whose certainty exceeded their knowledge. The Birmingham Six, the Guildford Four. Sally Clark, a British woman convicted of murdering her 2 infant sons in 1999, based in part on statistical evidence that was later shown to be fundamentally wrong, and who was acquitted on appeal after serving 3 years in prison. She died in 2007. The resonance of that last case was not lost on commentators following the Letby situation. Sally Clark had also been convicted of killing babies. Sally Clark had also been convicted on the basis of expert medical evidence, and Sally Clark had been innocent. By 2025, the case had reached a point of genuine institutional uncertainty. Cross-party politicians in the House of Commons were raising concerns. Conservative MP David Davis stated publicly that there was no hard evidence against Letby. The Criminal Cases Review Commission, the independent public body charged with investigating potential miscarriages of justice in England and Wales, confirmed it was considering an application on Letby's behalf. The Thirlwall Inquiry, a separate public investigation into how the hospital had failed to prevent the deaths, was preparing its final report. A report expected to focus on the institutional failures of management, not on the safety of the conviction. In April 2026, a senior healthcare executive from the Countess of Chester Hospital was arrested on suspicion of perverting the course of justice, a development that added yet another layer to a case that had already accumulated more layers than almost any other in recent British legal history. Lucy Letby herself, now 36 years old, continues to serve her sentences at HM Prison Bronzefield. She maintains her innocence. She has never publicly admitted to any of the crimes for which she was convicted. She has refused consistently to engage with the media. Her parents, described by neighbours in Hereford as well-liked ordinary people, have stood by their daughter throughout. The friend who described the peer support note-writing technique, Dawn, the childhood friend who had known Lucy since school, has continued to advocate publicly for a review of the case. And somewhere in the middle of all of this, and barely visible beneath the legal arguments and the expert panels and the political statements and the Netflix documentary and the parliamentary debates, are the families of 7 babies who are not alive, 7 children who did not grow up, 7 sets of parents who will carry the weight of what happened in that neonatal unit for the rest of their lives, regardless of what any court, any commission, or any panel of experts ultimately concludes. What this case reveals about how a society decides who is guilty is ultimately more disturbing than any individual detail about Lucy Letby. Consider what is factually indisputable, the points on which opposing sides agree because the evidence leaves no room for disagreement. Babies died in the neonatal unit of the Countess of Chester Hospital at a statistically anomalous rate between June 2015 and June 2016. That is real. The numbers exist. The deaths happened. Lucy Letby was present during the shifts in which virtually all of those events occurred. That is real. The shift records exist. The correlation exists. The hospital knew there was a problem in 2015 and chose repeatedly not to escalate the matter to the authorities until 2017. That is real. The Thirlwall inquiry documented that failure in considerable detail. 2 juries, in 2 separate trials, heard the evidence and convicted Lucy Letby. That is real. The verdicts exist and carry the force of law. 14 international medical experts reviewed the same evidence and concluded that no crime was committed. That is real. The press conference happened. The findings were published. 5 facts, all verifiable, all real, and they are absolutely irreconcilable with one another. The case of Lucy Letby exists in a space that the legal system was not designed to inhabit comfortably, the space between legal certainty and scientific certainty. The legal system operates on standards of proof, guilty beyond reasonable doubt. To reach that standard, prosecutors present evidence, defenders challenge it, experts testify for both sides, a jury evaluates everything and decides. The system assumes that this process, conducted with sufficient integrity, will produce a result that is more likely than not correct. Not infallible, more likely than not correct. But the system also assumes that the expert knowledge on which it relies is stable, that when a pathologist states that a specific configuration of blood markers indicates only one thing, that claim is sufficiently robust to sustain a murder conviction. That when an air embolism specialist cites an academic paper as evidence that something was deliberately injected into a bloodstream, the interpretation of that paper will not subsequently be challenged by the paper's own author. On that point, the Letby case becomes something more than the story of a nurse and dead babies in a hospital in the north of England. It becomes a question about what happens when the scientific foundations of a criminal conviction are pulled from beneath it, not by lawyers with a financial interest in the outcome, but by independent experts who have nothing to gain except accuracy. The Sally Clark case mentioned earlier is the parallel that Letby's defenders cite most frequently. In 1999, Sally Clark was convicted of murdering 2 babies, based in part on the testimony of Professor Roy Meadow, who told the jury that the chances of 2 babies in the same family dying of unexplained sudden death were 1 in 73 million. That number was wrong. It was wrong because Meadow had calculated the odds as if the 2 events were statistically independent, when in reality, the genetic and environmental factors that contribute to sudden infant death make events within the same family correlated. The error was identified. The Royal Statistical Society issued a public statement. The General Medical Council suspended Meadow temporarily. Sally Clark was acquitted in 2003 after 3 years in prison. She died in 2007, aged 42. The official cause was acute alcohol intoxication, but those who knew her described a woman who never recovered from what the system had done to her, a woman whose life had been destroyed not by her crimes, but by the errors of the system created to determine whether she had committed any. If Lucy Letby is innocent, that is the relevant precedent. And that precedent is terrible to contemplate. But there is another side to this question that also needs to be considered honestly. The possibility of innocence is not the same as innocence. Skepticism about the evidence is not the same as proof that the evidence is wrong. And the history of medical crimes perpetrated by healthcare professionals against vulnerable patients, a history that is documented, disturbing and far longer than most people know, suggests that the pattern of events at the Countess of Chester was not, historically, without precedent. Beverly Allitt was a British nurse convicted in 1993 of murdering 4 children and attacking 8 others on the paediatric ward at Grantham and Kesteven Hospital. She injected insulin into her victims. She injected air. She caused cardiac arrests in children who had been admitted with relatively minor conditions. She was caught, convicted, and sentenced. No international panel of experts emerged to argue that the babies had died of natural causes or inadequate care, because the evidence against Allitt was, in one crucial respect, more direct than the evidence against Letby. One of Allitt's surviving victims had insulin detected in her body at levels that could not be explained by any means other than deliberate external administration. The forensic signature was undeniable. Harold Shipman was a British general practitioner convicted in 2000 of murdering 15 patients, but subsequent investigations concluded that the true number was likely between 200 and 560. He used diamorphine. He falsified medical records. He was, by all external accounts, a competent, professional and trustworthy doctor. His patients loved him, his colleagues respected him, and he killed systematically over decades because no one around him could accept that a respectable physician was capable of it. The pattern here is not accidental. Healthcare professionals who kill vulnerable patients generally do not look like monsters. They generally look dedicated. They generally have reputations that make those around them reluctant to speak. They generally operate in environments, hospitals, clinics, specialist care units, where unexpected deaths are common enough to provide cover. And they are generally discovered far too late, after a pattern has accumulated enough force that the correlation can no longer be ignored. If Lucy Letby is guilty, that is the relevant precedent. And that precedent is also terrible to contemplate. What makes the Letby case truly singular, what distinguishes it from virtually any other high-profile criminal case in recent British memory, is that it does not resolve. It does not have the narrative shape that a criminal case normally has, even those involving dramatic claims of innocence after conviction. Normally, there is a turning point, a new piece of evidence, a testimony that collapses, a confession, an acquittal, or a definitive rejection of appeal that closes the public debate, even if the academic debate continues. The Letby case has not produced that turning point. 2 juries convicted, 2 appeals failed, and then 14 international experts stood up at a press conference and said there were no murders. And the Criminal Cases Review Commission opened an investigation, and the Thirlwall inquiry continues, and the investigation into hospital management continues, and the family's lawyers say the panel is a sham, and Letby's defenders say it is overwhelming evidence, and neither side is wrong about the facts they cite. It is possible that the Commission will determine the case should be referred back to the Court of Appeal. It is possible that a retrial will be ordered. It is possible that Lucy Letby will be acquitted. It is equally possible that the Commission will determine that the new evidence does not meet the necessary threshold, and that the convictions will stand. It is possible that the investigation into hospital management will result in charges. It is possible that it will result in nothing. It is possible that the Thirlwall inquiry report, still pending, will reveal systemic failures of such gravity that they completely reorient the public debate about who or what is responsible for the dead. As of June 2026, none of those outcomes has materialized. Lucy Letby is in prison. The case is under review. The debate continues. What is certain, regardless of how the legal system eventually positions itself, is the following. Babies died. That is irrefutable. Families were destroyed. Parents who brought their premature children to a hospital, believing that modern medicine would save them, and who did not go home with a living child. That is irrefutable. A woman is in prison for the rest of her natural life. Whether she is guilty of what she was convicted of or innocent of everything attributed to her, that fact exists with full weight and complete consequence. That is irrefutable. And a system, a hospital, a police force, a prosecution service, a court system, made decisions at every stage of this process that shaped the outcome. The hospital management that ignored the consultants, the investigators who built a case around a single suspect, the prosecutors who presented specialist evidence with a certainty that the experts behind that evidence now contest, the judges who rejected the appeals, the panel that said there were no murders. Every actor made decisions within a system that assumes itself sufficiently reliable to determine guilt beyond reasonable doubt. The question that Lucy Letby leaves unanswered, and that no verdict, no commission, no documentary, no press conference will ever be able to fully close, is how reliable that system actually is, when what is at stake is the lives of babies on one side and the freedom of a human being on the other. Legal systems are built by human beings. They reflect the extent of human knowledge at any specific moment, and human knowledge at any specific moment is, by definition, incomplete. That is not an argument for anarchy. It is not a claim that courts are worthless or that juries have no value. It is simply the observation that the history of criminal justice is the history of a society learning, very slowly and at very great cost, where its systems have failed, and trying to build better systems in response. Sally Clark was convicted because nobody checked the mathematics before it reached the jury. What happened at the Countess of Chester Hospital between 2015 and 2016 is still being checked. And while that happens, a 36-year-old woman wakes up every morning in HM Prison Bronzefield. She makes no public statements. She gives no interviews. She says nothing new about babies who died more than a decade ago. She simply exists within the system that convicted her, awaiting an outcome that may or may not come, in a case that the world continues to watch because it cannot look away. The most disturbing question in the Lucy Letby case is not whether she is a monster. It is that we are not certain. And in a legal system built on the presumption of certainty, not knowing is the most disturbing fact of all.